everyone. Today we are going to be talking about the topic of the most common construction site injuries and what workers should do first. Welcome to yet another informative segment of Live with Mitch from the law firm of Proner and Proner. I'm your host, Mel McGuiop, and we sit down with the expert himself, Mr. Mitch Proner, a personal injury attorney with over 30 years of experience, here to answer your questions or any interesting topics that you might find useful in the personal injury world. And just remember, folks, if you need to contact us, all consultations are free and confidential at 1-800-321-1234. Now, before we go on, I just want to do a really quick plug that if you want to meet us in person here in New York City, we will have a booth this Saturday, September 20th, for Indian Larry's Block Party. This is a motorcycle event, but that still doesn't mean you can't come and say hi. So please come by. We're going to have some nice little giveaways, and we'll make sure to flash that info right about now, I think. That's it. That was quick. That's basically our booth, and that's the flyer. But yeah, come on by. But anyway, how you doing, Mitch?
Good. As always, it's my pleasure to present some information, and hopefully it's informative and entertaining.
Yeah, definitely. I feel like I should be learning more today. There's just something in my head that tells me that.
That's a good attitude for every day.
Most definitely. All right, so let's get right into it. So today, we are going to be talking about the most common construction site injuries. You know, construction sites are some of the most dangerous workplaces in America. You know, falls and accidents happen every day. But what you do in the first few minutes is really important. So, Mitch, the question is, what are the most common injuries construction workers face? And what's the first thing they should do when they happen?
Well, first of all, the accidents typically occur most often from falls or falling objects or dangerous conditions like electricity. That's not safeguarded. Okay. Or lastly, getting caught between a vehicle and an object, or two vehicles getting caught between. The injuries that are sustained from those incidents, naturally, I've seen everything. When you fall from a height, depending on how you fall, the injuries can be to your limbs. Like the natural reaction if somebody's falling and they're upright is to try and land on their feet, and we see knee and hip injuries. But oftentimes you're not going to be successful, and then you get injuries to your torso and your head. A lot of times people, despite wearing a hard hat, get severe head injuries.
Yeah.
Sometimes the helmet comes off, sometimes it stays on, but you could still have a brain injury. And the most important thing is to report the incident and to get help.
So like, well, you know, that definitely goes into play for, like, especially for, I guess, for workers' comp. But does that also include, like, I guess, getting struck by falling tools or debris? I guess is another big one. And should someone respond in that moment?
You got two obligations under workers' comp. One obligation is you got to get medical treatment. Without medical treatment, you can't establish the claim. A doctor has to fill out a form called, in New York, a C4. Without medical treatment, you're not going to establish a workers' comp claim. But more importantly, you got to get yourself looked at, because the condition could be more serious than you think it is. And your health is more important than any money you're going to get from a claim. Because the money you get from a claim, you might have it, you might spend it. Your health you have forever. And a doctor with a timely treatment could make the conditions better. And oftentimes, waiting can be to your detriment, not just for the claim, but for your health. Have I had clients that waited to get medical treatment? Yes. I had a case where a client, he waited almost 30 days to get medical treatment. But he reported the incident at work. That's another requirement. You need to report the incident at work within 30 days. Otherwise, the claim can be denied. This guy, fortunately, he reported the claim at work. They filled out a form. He sat down. He didn't even miss any time from work.
Oh, wow.
But it was bothering him, and he was working demolition, which is hard work. And he continued to work for well over a month. And then he started to see a knee doctor. He ended up getting a multi-million-dollar verdict.
Oh, wow.
But he had a workers' comp claim as well. The verdict was for a third-party claim, but he had a workers' comp claim as well. And the workers' comp claim was established by him reporting the incident and then following up with medical care. So that's really important. That was a knee injury.
Okay.
And he kept working. He didn't think it was that serious, but it kept bothering him, and then he got a knee surgery. And then the surgery didn't do well, so he got a second surgery, went back to work, but couldn't work like he did before. Got a third knee surgery, then ended up getting a knee replacement and ended up getting awarded over $4 million, or actually $4 million, which we had to take a verdict because they weren't paying on it. And I presented the case in court, and we were successful. But it starts with reporting the incident. And that was a fall from an unsecured ladder, which is typical in a construction site. People often get injured because they don't have proper safeguards. They don't have adequate scaffolding. They don't have a safe place to tie off. They don't have a safety harness. And sometimes I see people working at work sites, and they don't even have hard hats. They're using bandanas. And it's not what they're entitled to under the law. And unfortunately, injuries do arise out of those incidents.
Now, does it matter actually? And I'm going a little off what we're talking about here, but do they have to be working a certain amount of hours a week to make that claim? Like,
there are
20
certain
hours a week?
occupations that you have to work a certain amount of hours. Like if somebody's a babysitter or a housekeeper, those individuals have to work 40 hours a week. But if you're doing construction, no, it could be your first day of work, and you could be working 15 minutes and you get hurt and you can bring a claim.
Okay, good to know. Now, I know we had talked about, slipping and falling tools, what have you, but caught in crushed accidents are unfortunately common. I mean, I know the immediate action that the worker should take is seek medical help, but is there anything else you'd like to
Yeah, so I had a case where a guy was down in a hole, and to remove some debris out of the way, they used a backhoe while he's in the hole. The wood snaps and
Oh, man.
crushes his arm between the bucket of the backhoe and the size of the hole he was in. And obviously, it was an easily preventable accident. They weren't using the equipment properly. He shouldn't have been near the zone of danger. And unfortunately, had this bad crush injury to his arm. And there are OSHA safety rules. Not everybody follows them. And then there's just what's reasonable conduct. And not everybody follows those rules. Often expediency, getting the job done, takes the place over safety. If somebody's working and they are injured,
Right.
as I mentioned, report it, get medical help, and then we can help you with the forms to make sure that the claim is brought in a timely fashion and that you're entitled to everything that the law says you're entitled to. And oftentimes insurance companies try to hold back those benefits and fight the obligation to pay those benefits because it's profitable for them to do so. Insurance companies do fight legitimate claims, and it's important to have a lawyer on your side to make sure that your claim is given the attention that it warrants.
Right. Can I throw a hypothetical at you?
Sure.
Let's just say that you do get injured, but let's just say you are knocked out, and obviously you can't fill out paperwork, your C3s, C4s, or whatever paperwork you need to fill out. What is the time limit that you have to respond or to get the ball rolling if there's no one to represent you?
You have to report the claim to your employer within 30 days, and then you have up to 2 years to bring a claim under workers' comp, and you have up to 3 years to bring the claim as a third-party lawsuit if there's another party involved other than your employer. And if you're exposed to a height-related risk, even if your employer gave you the bad ladder, you can bring a claim against the GC and the owner of the property if it's at a construction site or demolition. And those claims We've been successful in so many of them.
And that would fall under like premise, right? Liability, or is that involved with?
That's right. Premises liability. That's
Yeah.
correct. Premises liability would be against the owner of the property, and labor law claims would be brought against the GC.
So essentially, you can do workers' comp, the labor law ones, and the premise ones.
And the premises ones. That's correct.
Okay. So that's really, I don't want to say good news, but it's good to know that essentially you do have options. So yeah, I think I learned a lot today. I was quizzed by Mitch earlier. I have some notes I'm looking at, but not totally. But I'm weaving it together, so it's kind of coming into play.
It's a lot. It's a lot. Even after 30 years, I'm still learning. I say that not with any hesitation. Every case that any experienced trial lawyer tries, or inexperienced trial lawyer, doesn't matter. Every case that a lawyer tries, there's an adversary. There's never just one lawyer. It's always two lawyers representing at least two parties. Sometimes there's 5 or 6 lawyers if there's multiple parties involved in the lawsuit. And it starts off with a judge giving the jury preliminary instructions. Then the lawyer gives an opening statement, the one representing the plaintiff, the person bringing the claim. Then the defendants give their statements. And then there's presentation of evidence. Then there's a charging conference. Outside the presence of the jury, the judge typically does it in his chambers, and he brings the lawyers in, and he asks them for their request to charge. And the requests to charge are prepared by the lawyer, where after the evidence has gone in, the lawyer tells the judge, based on the evidence in the case, this is what I think the law is and what the jury should hear that they need to decide based upon the law. And then the defendant's lawyer says, these are my requests to charge. And the judge looks at the 2 requests to charge. And the plaintiff's lawyers always want different charges than the defendant's lawyers. And then at the end, the judge looks at the charges and he decides. And he might ask for argument on it. And then the judge will tell the lawyers, this is what the law is of the case that I'm going to charge the jury. Then the lawyers give their closing arguments once they know what the judge is going to charge them. And then the jury hears the evidence. The law that the judge charges the jury with. And then the jury decides the evidence. So the law is different for every case. And lawyers might think, oh, well, this is a simple left turn case, or this is a simple labor law case where somebody fell off a ladder. Every case, the judge has a charging conference, and every case, the lawyers argue with the laws, and every judge comes up with their own set of charges, and every case is different. And then sometimes they go up on appeal because the lawyers think the judge charged the jury the wrong law. And then the appellate division can say, well, it was wrong, you have to try it again. Or they could say, it was wrong, but the error was harmless, we're going to let the verdict stand. Or they could say, no, it was a good charge, and we're going to let the verdict stand.
Okay.
But cases go up on appeal just because even after 30 years, every case, we don't know what the law is, and we have to do research and figure it out. Of course, after time, you learn the general concepts, and they stick with you. And for me, doing it a long time, I'm pretty aware of the general concepts. But for each case, almost every day, I'm still doing research, and I enjoy it. So the fact that you are learning today, welcome to the club. That's part of being in a law office, and it's an important part.
Yeah, I definitely agree to everything you said, and it helps me understand, and hopefully you all too who are watching or listening, the angles that you need to approach, and just in terms of listening and just understanding what a good lawyer like Mitch Proner is doing, and just trust and have faith in him too. But yeah, I mean, there you have it, folks. I mean, I usually say this at the end, but I know you learned a lot, or I know I learned a lot. I hope you did too, but I definitely learned a lot today. But you heard it today from Mitch Proner, And that'll do it for now. And thank you for taking your time to tune in. Now, whether it's on our podcast or video broadcast, we really do appreciate you taking the time. And as always, remember, you can call us 24/7 at 1-800-321-1234, where consultations are free and confidential. And if you haven't done it yet, please follow us on our Instagram, TikTok, Facebook, and of course, YouTube. Like, share, and please subscribe so you get the latest updates. Anything else you want to add, Mitch?
No, I'd say most importantly, hopefully you're safe at work and you don't have any injuries. But if you think you might have suffered injury, get medical attention, report the incident to your boss, then give us a call and we'll try and help you out.
There you go. Thank you so much, Mitch. Oh, and real quick, another reminder. If you are free this Saturday, we will be here in New York City, in Williamsburg at Indian Larry's. So come by and check us out. We'll be there from 12 to 5. But yeah, thanks again, Mitch, for yet another informative session with you. And thank you all for checking us out. I'm going to say it still. I know I learned a lot, and I hope you did too. We'll see you next time. Thank you, Mitch.
Thanks, Mel. Be well.
You
Bye-bye.
too.